challenges of increased regulation on the practice of medicine have increased awareness of the agencies that oversee healthcare services. This video reviews the composition, purpose, and scope of the Texas State Board of Medical Examiners, the relationship between the board and professional associations, the licensing process, the responsibilities of the licensee, common violations of the Medical Practice Act, the investigative process of the board, and the use of informal settlement conferences to resolve issues.
Well, I just sent off my application for my Texas license. What a process that was. I've never seen so many documents that had to be just so.
I am so glad that is all behind me now. But that's probably something you know a lot about. I understand you are on the Texas State Board of Medical Examiners.
That's right. I was appointed by the governor, had to be confirmed by the Senate. I served for 6 years. It was quite a deal.
Really?
It was very interesting. Because of that, I understand more about the board than I did before.
Who's on the board anyway?
12 physicians, 3 DOs and 9 MDs, plus 6 public members, 18 in all. They represent a wide variety of backgrounds. They're appointed to serve the public interest by the governor's appointment office.
Oh, so the board represents the public. Somehow I always thought they represented medicine.
Well, in setting up the board, the legislature determined that the practice of medicine is a privilege, not a right.
Ah, so it's a privilege to do what we do.
Well, here's a good question for you. Why don't you explain the relationship between the professional medical associations and the board? Like, who does what?
Well, they have some common interests, but very different functions. The board is a state agency that issues our licenses and is accountable to the public, as I said earlier. The professional medical societies, such as the Texas Pediatric Society, and professional medical associations, like the Texas Osteopathic Medical Association and the Texas Medical Association, are private membership organizations. We pay to belong to those organizations. The organizations represent our interests, which does, of course, include concern for the patients that we serve. The medical association representatives may meet with the board to discuss issues. They can lobby the legislature, which the agency can't, to get the Medical Practice Act or other laws changed.
Okay, that explains a lot.
I guess licensure is the main thing the board does?
Licensure, of course, but their charge is more than just that. It's to be sure the doctors they license are qualified and practice properly. The board also has a disciplinary function.
Where does the board get the money to do all that?
The board receives a budget from the state legislature. The legislature expects them to carry on within that budget, not based on what they collect from licensing fees and administrative penalties.
I see.
There's a lot to learn about regulation of medical practice. The internet has helped to provide access to information. You can go to the board's website and get copies of the Medical Practice Act, all the board's rules and position statements, board member profiles, dates of board meetings, disciplinary orders, and more. You can even save money by downloading the licensure application. And renewal applications are also on the web. They have lots of useful links for orders, newsletters, and profiles. They've done a good job with their website.
What is the website?
tsbme.state.tx.us. Now, if you forget that address, you can use any search engine and type in TSBME, and it will identify the board's website. So, you've just submitted your application for licensure.
Oh, yes, and I'm anxious to get that done.
Well, you're lucky you're a resident with a clean record. The board has streamlined the licensing process with a much shorter application and methods to help physicians with clean applications get their license quicker. It's now possible to get licensed within weeks when all the submitting documents are in. In the past, the whole process could take 9 months to a year, especially for physicians who practice in numerous locations.
Well, I just hope it goes fast.
Well, let me give you some advice. When you ask someone to submit documents directly to the board, make sure you follow up.
Okay.
Sometimes a request can just sit on someone's desk or get lost in the mail, and that can slow down the whole process. Now, at some point, the licensure analyst assigned to review your application will send you a lacking letter telling you what documents are still needed in your file, so you have to follow up.
Great, I'll watch for that.
Now, while I'm handing out advice, it would not be a good idea to make any commitments, like signing a contract or buying a house, not until you get your license, because of the potential delays.
Right.
Now, once your licensure application is complete, it's passed all the internal reviews, you will be notified that you are eligible to take the JP exam, the Texas Medical Jurisprudence Examination.
Not another test.
Don't worry, the board will tell you what study materials to use. I highly recommend that you study for the JP exam. It's a 50-question multiple choice test that covers lots of law. You have to know the law on advanced directives for end-of-life decisions, various reporting requirements. You need to know what you can and cannot do as a physician, like when you can delegate.
Okay. Now I've got a question. I'm applying for a license here in Texas, but maybe heading up north after I get my license here. Now, how does the board keep track of doctors who move around?
Well, I'll tell you one thing. If you want to keep your Texas license, you are responsible for keeping the board updated on your whereabouts. Notify the board of your new address, or you could miss a mailing, like your renewal notice. You are held responsible for that renewal regardless. Some doctors end up practicing without a current license because their licenses lapsed after they moved and they missed their renewal notice. The board is not responsible for tracking you down when you move.
That's good to know.
Now, what about a name change? How does the board deal with that?
If you change your name after the board has issued you a license, you can fill out a request, and for a small fee, of course, they will issue you a new license with your correct name. On the other hand, if you lose your license, the board will issue you a license with duplicate printed on it, also for a fee.
So, what do I need to know to stay out of trouble?
Well, just as you mentioned earlier, we have to keep up with the law. Professional meetings and publications like the board's newsletter, which is now on the website, are good ways to know when laws have changed. Then, get the facts and see what you need to do to comply.
You mentioned earlier that there's some things that we have to report. What do I need to know about that?
Well, for example, if you, even as a resident or a medical student, know that a doctor is unsafe to practice, the law says you have to notify the board or your license is on the line.
Whew, I'll bet that can be tough.
Yes, but your license requires it.
Also, you have to report certain diagnoses like contagious diseases and certain injuries like submersion injuries to the Texas Department of Health. And of course, like other professionals, we have to report suspected cases of child abuse, elder abuse, sexual exploitation. There are other things as well. Now further, you need to remember that ethics may dictate you report some things you don't have to report, like domestic violence.
Speaking of that, did you know that as part of our CME, we need 1 hour of credit in ethics and professional responsibility? Each year, we're required to have 24 hours of CME. Half of that needs to be formal Category 1 hours. That includes the ethics hour. Also, not required, but the board recommends that doctors who treat patients for pain take a CME in pain management.
So, is that on top of our residency training and going through board certification?
That's a good question. The way it works is when you get board certified, you can count certification or recertification in lieu of 24 hours CME credit. That is basically the CME for 1 year within a 3-year period.
So, how does the board keep track of our CME?
Well, the board doesn't, but you sure need to. When you fill out your licensure renewal form, you report that you have met the requirement. And trust me, don't send reports of your CME in with your renewal application. Just answer the question. The board only asks for CME documentation from a random sample of doctors.
Now, earlier you were talking about the disciplinary role of the board. Just what do doctors do that gets them into trouble?
Well,
Some situations may involve more than one violation. Quality of care issues. About half of the violations concern failure to maintain an accepted practice standard. Examples are exercising poor judgment, lack of knowledge or skill, or simply negligence by the doctor. Next comes unprofessional or illegal conduct that includes a wide variety of violations. Examples are providing false information, accepting kickbacks for referrals, and overcharging or overtreating. Then there's drug and alcohol abuse. It is as big a problem for doctors as it is for the rest of the population. The issue with physicians is, if we practice medicine under the influence of substances, alcohol or drugs, we have the potential to harm others. An elevated blood alcohol level can temporarily impair your thought process. Of course, fraudulent delegation and inadequate supervision is an issue. There are specific oversight requirements that physicians must meet in order to delegate certain medical functions to other professionals or to their office staffs. Last but not least is sexual misconduct or exploitation. That is a serious problem for physicians considering the unique relationship we have with our patients. We must be careful not to get involved in inappropriate relationships with our patients.
You know, a violation of any board rule is the same as a violation of the Medical Practice Act. And the board has many rules. You'd be amazed at some of the doctor problems that come before the board. Some physicians abuse drugs or alcohol, or have a physical or mental illness that interferes with their ability to practice. The Texas Osteopathic Medical Association and the Texas Medical Association both have effective physician rehabilitation committees to assist the physician to seek early intervention and effective treatment programs for those problems. Rehab programs are very important for our profession. We're human, you know. It's a challenge.
The doctor who mentored me into going to medical school is under contract with the Physician Rehab Committee. He has a problem with alcohol. Now, his partner contacted the committee, and they were really helpful. My mentor agreed with the contract with them before he really got into trouble.
That's the way it should work. The Rehab Committee doesn't have to report to the medical board as long as the physician cooperates with the agreement and is not a threat to public safety. The goal is to protect the public while rehabilitating, salvaging, if you will, the physician.
If the physician does not cooperate, or if the physician poses a threat to patient safety, the physician must be reported to the board.
Now, what about delegation issues? What does the board say about supervising and delegating? I'm planning on having a physician's assistant or an advanced practice nurse work with me in my OBGYN practice.
Well, as physicians, we have very broad delegatory power. Be sure that you're delegating to persons who can safely do what you delegate and that it's legal for them to do it. Even then, we're still responsible for what we delegate. For example, we can train our office staffs and delegate certain functions to them under our direct supervision. The problem comes up when we hire unqualified staff and delegate inappropriate functions to them or don't provide oversight. Now, we can delegate prescriptive authority to PAs and APNs in underserved areas, in our offices, and in hospitals or nursing homes. There are rules in each case that must be followed. Certain documentation and supervision is required.
Now, is it true that we can delegate a patient's drug management to a pharmacist?
Yes, we can, but again, only as defined under the board's delegation rules.
I hear all sorts of horror stories about billing fraud and such. I generally like to think of physicians as law-abiding citizens, but I guess that's not always the case.
Well, you have a right to be concerned. When you prepare for the JP exam, you'll learn about many laws that are potential for civil or criminal action against a physician. Many of those laws have to do with business and billing practice. That is, billing for services not provided, billing for services at a higher paying code than is justified, or in some other way falsifying reimbursement claims. Virtually all third-party payers, including Medicare, have guidelines for documentation required for reimbursement.
And they keep changing them.
I know, and they'll continue to change. We have to stay up with what we're required to do to support billing. Some documentation problems may not be criminal or otherwise be illegal practices. Some may concern failure to adequately document services in a timely manner. We may fail to write enough about what we're thinking, why we did or did not do some test or order some treatment or medication. That can be a quality problem. Documentation is a big issue.
What about other federal and state laws?
Well, there's the federal Stark law that prohibits you and your immediate family from having investments in a health service where you send business, such as a lab or imaging service. You really need to watch out for that if you're investing. If you're on call at the emergency room, you'd better know about EMTALA, the patient transfer laws. EMTALA requires screening and stabilization at any emergency condition. Failure to respond to your call can get you and your hospital in big trouble. Now, we also need to consider the Office of the Inspector General's guidelines for physician practices concerning preventing and detecting fraud and illegal conduct. Also, patient privacy has become a major issue with the increase in electronic billing and information exchange. So the Health Insurance Portability and Accountability Act, referred to as HIPAA, has requirements concerning release of patient health information.
Now, I've been wondering, does the board say anything about advertising? In the past, I don't remember doctors advertising, but now it seems to be the common thing with patient testimonials and all.
So can doctors advertise legally and ethically?
Yes, the law permits us to advertise as long as it's not false, misleading, or deceptive, and can be readily verified.
A physician cannot advertise for patients to come in for a free eye exam, then turn around and bill the insurance company. Physicians cannot advertise in a way that would take advantage of susceptible people. An example would be use of scare tactics to get people to come in for tests or treatment that they may not need. Physicians cannot advertise in a manner that would cause confusion about their credentials. For example, physicians cannot just advertise board certified. Physicians are required to state the exact name of the board by which they are certified, and that board must be approved by the American Board of Medical Specialties or the American Osteopathic Association Bureau of Osteopathic Specialists. Physicians cannot advertise that they waive copays or that they accept a benefit plan payment as payment in full. If the physicians did, they would be advertising that their actual rates were less than what were reported to the insurers. Physicians cannot use patient testimonials in advertising if it might be misleading to the public. If you insist on it, use patient testimonials very cautiously. Such use can be fraught with problems.
Well, that's good to know before I get myself into trouble.
So tell me, what triggers an investigation by the board?
Well, there are several triggers.
First, anyone can file a complaint with the board against a physician. For example, it can be a patient or family member, another physician, or other professional. Entities taking adverse peer review action against a physician are required to report that action to the medical board. For example, if a hospital restricts the privileges of a physician on staff, that action has to be reported to the board. The board must investigate to determine if the matter involves a violation of the Medical Practice Act. Liability insurers who receive a claim or complaint about a physician are required to report the claim as well as the disposition of the claim to the board. If a physician has 3 or more claims in a 5-year period, the board is required to review those claims, but can also investigate any claim at any time. Uninsured physicians are required to self-report when a malpractice claim is filed against them. If the Medicare or Medicaid programs take adverse action against a physician, the program is required to report that action to the medical board. For example, if a physician's Medicare provider status is terminated, Medicare must report that to the board. A court proceeding that finds against a physician must be reported to the board. For example, if a physician is found to be incompetent by a court, that is reported to the board. Finally, the board itself can initiate an investigation based on any source of information.
So does the board investigate every little complaint that comes their way?
Well, to some extent, yes. The board screens each complaint to determine if it may be a violation of the Medical Practice Act. That is, if they have authority to act. If the issue is appropriate for board action, then an investigation is opened. The board staff determines what parts of the Medical Practice Act may have been violated, and that pretty much drives the investigation. If clinical competency is an issue, the investigation is done by a clinical staff member using a board-approved consultant who practices in the same general area as the subject physician.
About how many complaints does the board get in a year?
Well, as I recall, in a given year there may be as many as 5,000 complaints. About 60% of those turn out not to be a violation, what they call non-jurisdictional. Keep in mind, many complaints are filed with the medical board not because the doctor did something wrong, but because he or she did not know how to communicate with the patients and their families. Delivering bad news is an example. Or dealing poorly with medical errors if the physician did something wrong. While I was on the board, I was amazed how many doctors came before us because they simply didn't understand the significance of the physician-patient relationship. I myself had to learn from experience how to deliver bad news. I don't like to think about the people I may have hurt trying to be stoic. For example, too many doctors deliver bad news in the hallway and in a hurry. The family receiving the news can't take in the information. They end up feeling angry. They think the doctor doesn't care about them or the situation. Sometimes they think the doctor has abandoned them. So, to get even, they file a complaint with the board, or they may even file a lawsuit. It's all in the details. Delivering bad news. Let me share with you what I've learned. This is one of the most difficult responsibilities in the practice of medicine. Before you approach the patient or family, prepare yourself. Consider the information you may need to answer their questions. Locate a private, quiet place to meet with the family. And I found it's been very helpful if I mentally rehearse what I'm going to say and how I might respond to their possible reactions. Most patients and family members want you to be honest and empathetic when you give them bad news. But be sure to tailor your approach to the individuals involved. Give them information in terms that they can understand. Use touch only when it's appropriate. Remember, some patients or family members prefer not to be touched. That's okay. It's also okay to share your emotions with patients and their families. Be open to their questions or expressions of anger or frustration. Take time. Listen. Answer questions honestly. A lot of how you interact depends on your relationship with the patient. At the close of the meeting, express your concern for them and ask about their spiritual and emotional needs. Offer to share information about other resources to help them. Do what feels comfortable in the situation to express your sadness and caring for them.
That's good. Now, how would you handle medical errors?
How to deal with medical errors. I don't care if you're the best doctor. You're going to make mistakes. You're human. Good people make mistakes. It could happen to anyone given the right set of circumstances.
But why do some medical errors result in the filing of a complaint with the board, or maybe even a liability claim, and others don't? What do you think makes the difference?
There could be several reasons. There are actual studies that confirm that if a physician is open and honest with a patient and their family about a mistake, the patient is less likely to file a claim. I found the best way to discuss medical errors is, for one, to do it as soon as possible. Otherwise, the patient may think that you're trying to cover up. It's better if you tell them, rather than they learn it from someone else. In fact, you have an ethical and fiduciary duty to tell them. Review the circumstances step by step. What led to the medical error? Give rationale for why you did what you did. What were you thinking at the time? Select your words carefully. Don't overstate or understate. Let them know what you learned from the mistake and have taken steps to avoid repeat events, and that you care and that you're there to help them work out the problem. The patient and family need to know what happened so they can begin to deal with it and move forward.
Anything else?
Yes, there is. Take it seriously, but you can't hang on to it. Don't let yourself continue to feel guilty and depressed. You have to let it go. And remember, the physician's attitude and communication skills play a crucial role in how well patients cope when they receive any type of bad news.
Good advice. Now, tell me, just how would I know that a complaint has been filed against me?
You'll know. The board sends a notice to the physician when the complaint is confirmed. Now, if the board needs to do initial investigation of, say, non-therapeutic prescribing, alcohol or drug abuse, or sexual exploitation, then the notice may not be sent until after certain parts of the investigation are done. Usually, though, you will be notified to give your side of the story early in the process.
Well, I assume we get to defend ourselves.
Sure. You're given an opportunity to provide information to the board and to answer questions that the investigator poses. Depending on the issues, that usually involves providing medical records and explanations. The investigator may come to your office or the hospital, or may handle most of the investigation by mail and phone.
Okay. Say a friend of mine receives notice of an investigation from the board. What do you recommend my friend do?
Well, first of all, your friend should take it very seriously. He or she must provide all the information and documents that the board requests. That includes medical records, financial or billing records, any documents that he or she may have, including documents otherwise treated as confidential.
Should her friend hire an attorney? I've heard that you shouldn't go to a meeting with the board without an attorney. Is that true?
Well, her friend would need to consider early on whether or not he or she needs an attorney. Depending on the issues, and certainly if it looks like the friend will be asked to come before a meeting, it would be wise to get an experienced attorney involved. Also, it may be good to ask a physician colleague to help work through the issues, who can help determine what the problem is and what needs to be done to fix it.
So you have a complaint filed against you, and the board investigator determines that you may have violated the Practice Act. You know you're in trouble. Then what?
There are several possible steps. First, in some instances, if you agree that what you did was wrong, then you might need to get an attorney and see about working out an agreed order. For example, you might agree to correct the situation and accept certain admonitions or restrictions, or even a fine, and avoid a hearing. Second, you may be invited to come to an informal settlement conference, or ISC as we call it. You will be given the investigation findings and meet with representatives of the board to account for what happened. Of the 1,500 or so complaints that are investigated each year, about 20% or more are heard by an ISC panel.
Now, is the ISC panel like a regular court hearing with court reporters and rules of evidence and all that?
No, it's more like a structured mediation, less stringent than a court of law. It's an informal, private meeting. The purpose of the ISC is to explore the issues, hear the facts of the case, to share information, and seek to arrive at some conclusion. If you feel you need an attorney, bring your attorney and witnesses if you want to. Needless to say, it is extremely important to go to those meetings well prepared and to anticipate questions that may be asked. After considering all the evidence, about 1/3 of ISC panels determined that there was not a violation.
And the other 2/3?
The other 2/3 or so, the board panel makes a recommendation to the board for an agreed order with varying combinations of stipulations or requirements. The board actions range from revocation to administrative penalty with various requirements.
But what if the doctor doesn't agree with the proposed order?
Well, then the matter may be referred for a public hearing. The State Office of Administrative Hearings, or SOA, not the board, conducts the administrative hearings. The complaint filed at SOA is a public record. Those hearings are judicial hearings. They have a court reporter, sworn witnesses, and rules of evidence. After the hearing, the administrative law judge makes recommendations to the board. Either way, the agreed order or board order may include whatever restrictions or requirements the board considers appropriate to the issues at hand. Either may be probated, meaning the physician may continue to practice provided he or she complies with the requirements in the order. If an order is probated, the physician is overseen by a probation officer who receives reports or may conduct unannounced visits to collect urine or blood samples, whatever is required to confirm compliance with the order. Failure to comply can result in revocation of the probation. Whether a matter is handled through an ISC panel or a public hearing, the recommendations are made to the board. Then the board as a whole makes the final determination, not the ISC panel or the administrative law judge.
Okay, so only the full board can take away a physician's license, right?
Well, there is one exception.
There's always an exception.
I guess that's true. If an investigation reveals the physician poses a real danger to the health or safety of patients, the case can be referred to a group of 3 board members currently serving on the disciplinary panel. They review the findings and can order an immediate temporary suspension. Along with a notice of temporary suspension, they also send a notice for a public hearing to give the physician an opportunity to defend him or herself. If suspended, the physician has a series of due process options.
Can the board issue a private reprimand or order?
No, the board can't issue a private disciplinary or punishment order. However, they may issue a private non-disciplinary rehabilitation order if that's appropriate. Like the doctor friend you mentioned. For example, if he had self-reported to the board, they might have issued a private rehab order. It is used at the discretion of the board for a physician who self-reports alcohol or drug abuse or a physically debilitating condition. If the board then determines that the physician is being effectively rehabilitated or treated and is able to practice medicine without posing a threat to patient safety, such an order is not subject to open records and is maintained confidential or private.
Now, can the rehab order be probated like the other orders?
Yes, it can. The rehab order usually requires that the physician continue to participate fully with the physician rehab committee, or to have the treating physician report to the board on a regular basis, whatever is required to protect the public. The board has a comprehensive and effective drug testing program. The board is determined to make sure that only safe practitioners will be out there practicing medicine.
How does the public know that the board's taken action?
For the disciplinary orders, the board is required to release that information through an open press release format and to places where the physician practices. Information on board actions is readily available on the board's website, as I mentioned earlier.
Well, how do doctors know about actions taken against other doctors? Do we always have to go to the website?
Yes, the newsletter that was previously prepared and mailed to all licensed physicians is now available only on the website. Of course, anyone can contact the board at any time to determine the licensure status of a physician and can request a copy of any public disciplinary order.
Now, the National Practitioner Data Bank, does the board report to it?
Yes, they report licensure action to the data bank. The data bank is also used to track various adverse peer review actions, professional liability claim payments, actions against physicians. And with the addition of the Health, Integrity, and Protection Data Bank, the data bank also tracks criminal actions involving fraud.
It sounds so high-tech. There are so many new issues facing us in medicine today. Why, I'm thinking about joining a practice that has an electronic medical record system. I know that the medical records, the communications, it's all on the computer, and they use the internet. So how is the board dealing with telemedicine and internet access for healthcare services? And what about alternative therapies?
Well, those issues are complex and evolving. The board continues to address the issues with position statements. As time passes and more information is available, they will be formalized into new rules. For example, the board has issued rules concerning the practice of integrative and complementary medicine and on unlicensed practices. Unlicensed practice concerns persons out of state who aren't licensed in Texas but make decisions that impact on the diagnosis and treatment of patients in Texas. To deal with that, the board has a telemedicine license for practicing medicine across state lines.
Thanks. That's good to know. Now, what about using the internet?
On the internet issues, basically the board is concerned that a physician performs an appropriate one-on-one examination of a patient before prescribing medication or other forms of treatment. Can that be done properly over the internet? No, not now. But this is a rapidly evolving field. But you always have to consider confidentiality when you're dealing with the internet and electronic communications and billing. Federal regulations on privacy deal with that.
I know we got to continue rounds, but before we go, could you tell us a little bit more about the Informal Settlement Conference, the ISC? Seems like a pretty important process to know about. And yes, our friend probably needs to know about that too.
Sure. Let me first review briefly the final outcomes of an investigation. Then I can walk you through a typical ISC. After reasonable investigation, the board may dispose of a complaint related to the Medical Practice Act in several ways.
The board may dismiss the complaint if it determines that it does not have jurisdiction over the issue or that there was no violation. If there are violations to be addressed, the board can issue a public agreed order, a public board order, or a private non-disciplinary rehabilitation order.
The board order may require several things of the physician. It may include certain stipulations, such as requiring a mental or physical examination and treatment, specific CME, supervised practice, public service, or even an administrative penalty. It may restrict the license, that is, limit the scope or conditions of practice, or it may suspend or revoke the license. In any case, at the discretion of the board, an order may be probated, as I mentioned earlier. That is the outcome of an investigation and board action. I wish you could look in on an ISC and see how the board and the physician get to that point through an ISC, or show compliance, as we call it. As the investigation of a complaint progresses, the investigator reviews the medical records and other documents and may conduct interviews with the patient and with the physician. The investigator may visit with the physician's office staff or with hospital staff. If there appears to be a need for a meeting to confront the issues or exchange information, then the board may give the physician an opportunity to come to an ISC. The physician can bring an attorney and witnesses. Prior to the ISC, the board provides the physician with a written notice about the meeting, a statement of the allegations to be addressed, information about the board and the Medical Practice Act, and the rule concerning the ISC. The ISC is a means to review the findings of the investigation and share those findings and concerns with the physician, then for the ISC panel to hear what the physician and any expert witnesses have to say to address the concerns of the board. After discussing the issues with the physician, the panel then makes recommendation to the board concerning the disposition of the matter.
Perhaps we can look in on an ISC that is underway. Let's see. At the head table are two board representatives, the panel. One is always a physician, and the second person may be a physician or public member of the board, or may be a member of a district review committee. The district review committees are appointed by the governor to assist the board in carrying out its duties, such as assisting with the ISCs. To the right of the panel is the board's general counsel. That attorney's job is to advise the panel concerning the rules and to make sure the process is carried out properly. At the table to the left of the panel are the board attorney and investigator, who have been working on the investigation and who will present the board's case. At the other table to the right of the panel are the physician and his attorney. The person who filed the complaint is invited to the ISC. If they wish to come, they can state their complaint in person, but cannot stay for the discussion between the panel and the physician. Let's listen in while the general counsel opens the meeting.
On behalf of the Texas State Board of Medical Examiners, I want to welcome you to the Informal Settlement Conference. This is an informal meeting. We will not be swearing in witnesses. There will be no rules of evidence, as in a contested hearing. We will not be recording minutes. It is an informal meeting. This meeting is convened because the board determined a need to discuss the allegations with you and to hear what you have to say. First, let's introduce those present. My name is Joe Ryan. I am General Counsel of the Board, and I will be assisting the panel in its deliberations. To my left are panel members Mary Jane Roberts, a public board member, and Dr. Fred Hernandez, panel chairperson. To the panel's left are Jill Haley, an attorney with the board, and Rosa Flores, who is the investigator in this matter.
I'm Joanne Garcia, and I'm representing Dr. Jack Jones. We appreciate the opportunity to meet with you on these issues. I trust that you received the documents that we submitted for your consideration.
Yes, we did, and we have reviewed those documents. Thank you very much for submitting them to us. Let's move forward and have the board staff state their allegations and investigative findings thus far in this matter. When they finish, Dr. Jones, you'll have an opportunity to respond, and we can discuss the materials that you sent us. Are there any questions before we begin? No? Then let's proceed.
Based on our findings, we believe the doctor has violated Section 164.051A6 and 7A of the Medical Practice Act concerning practicing in an unprofessional manner and unprofessional conduct likely to harm the public. We received a complaint concerning the doctor's abusive conduct toward the medical record director and the nurses at the hospital where he practices. We have 2 documented complaints of abusive behavior toward nurses when they contacted him about patient care matters. Ms. Flores, would you review the findings of the investigation, please?
Yes. We have a video taken by the security camera in the medical record area when the medical record director advised Dr. Jones about his deficiencies in documentation. In the process of the investigation, we reviewed the records the director was concerned about, and we found that the doctor has a practice of not recording progress notes in a timely fashion, and often they are not legible. Several dictated histories and physicals are noted as, quote, dictated but not read, and the H&Ps appear to contain several obvious errors.
Doctor, I believe you're familiar with these documents and are aware of the situations the investigator and the board attorney addressed.
Yes, I am.
Doctor would like to hear what you have to say.
Okay. I guess I was under a lot of stress, and I was taking it out on the staff at the hospital. I don't know if you're aware of this, but prior to these events, My partner had moved, and I'd been covering the practice for the both of us. That day, the medical record director got on my case. I just lost it. And the nurses, they had every right to call me, and I should have not have taken it out on them. I've already made some changes, and I gave you a report of these things. Seeing myself on that film really got my attention, and I realized just how out of control my anger had become. That's not my true nature, and I've apologized to each of the persons that I've offended. I found a good counselor, and I've enrolled in an anger management class. I started that 3 weeks ago, and it's going very well. That has already been a big relief to me. And I know that my handwriting's never been very good, and the busier I get, it seems to be worse. I've tried to slow down and document better, and but I'm looking into getting a voice dictating equipment that will put the typed dictation immediately on the record. And I'm working with the hospital on making those arrangements to happen. I know that will help. I just want you to know that I fully realize that I am responsible for correcting that dictation before I sign off on it.
Doctor,
The
could you
group
be more
discusses the
specific about
issues
your
until all
anger
present
management
have had
program?
sufficient opportunity to make their comments, and the questions are answered to everyone's satisfaction.
Involved in a class that's
If there are no further comments or questions, the panel will consider its recommendations.
Panel members are considering the complaint and investigative evidence, as well as the physician's response, and are arriving at a recommendation. They can recommend closure if they feel there is no violation, or they can recommend an agreed order. In the agreed order, they can propose whatever stipulations they believe to be appropriate to the concerns. It looks like they've reached a decision. Let's see what this panel is going to recommend.
Doctor, we've considered all the issues in this complaint and investigation, and we've determined that your behavior constitutes a violation of the Medical Practice Act and represents unprofessional or dishonorable conduct that could pose a threat to the safety of others and interfere with quality medical care. We commend you for the efforts you've already taken on these issues. However, we are going to recommend that your license be suspended for 5 years and that the suspension be probated. We're also going to recommend several stipulations in the agreed order. We're proposing as follows. First, we want a description of your current anger management program. The board must approve that course. If the course is appropriately certified, you will provide documentation that you've successfully completed the program. If the course does not meet with board approval, you will enroll in and you will successfully complete an approved program. Second, we want you to continue with your counseling, but we must approve that counselor and have him or her report directly to the board on a quarterly basis. Third, we want you to pursue the dictation equipment that you mentioned, but meanwhile, we need to be sure that your progress notes are legible and timely. Fourth, you now know that you should not sign off on dictation as dictated but not read. You and you alone are responsible for the content of your reports, and your signature confirms that. We want you to arrange with the hospital for some of your records to be reviewed and a report submitted on a quarterly basis concerning the quality of your documentation. And fifth, we want you to meet with a panel of the board once a year for the next 5 years to discuss anger management and documentation. So, do you have any questions?
The board staff will draft up a written agreement, including these recommended stipulations, and get that to you. You may accept these stipulations or you may reject them. If you accept these stipulations, you will need to sign the agreed order and return it to the board in the time stated. If you reject them, the matter will be referred to the State Office of Administrative Hearings for a public hearing. I want you to understand that these stipulations are recommendations of this panel. The full board will consider the recommendations and may modify, accept, or reject them. Only the full board can take action on your license under these circumstances. Do you have any questions?
No, I don't.
We thank you for your consideration of these issues. And yes, I do have one question. Do I understand that Dr. Jones can return to the board in a year and request a modification of the order? For example, assuming that all is going well, can he make that request when he meets with the board panel next year?
Yes, that's correct. If he is planning to request a change in the order, he will need to notify the board staff prior to the scheduled meeting with the panel.
Thank you. We will look for the written agreed order to review and be back in touch with you.
We will get that to you. Thank you for coming, and we hope these issues can be resolved.
It pays to know the law and to be sure that your practice is in line with the law and professional standards. You can see that this physician was well prepared in advance. He clearly took responsibility for his problems. This is generally a good thing to do. The medical board tries to be fair with physicians, but will take whatever action it believes is in the best interest of the public. Now, that case was not nearly as serious as some of the cases that come before the board. Drug and alcohol abuse is far too common, as is sexual misconduct. Some of the cases involve criminal acts, others are serious practice issues that have resulted in permanent injury or even death to a patient. Some cases are situations where no harm was done, but the physician failed to take reasonable measures to protect patient safety, and bad things could have happened. Well, I'm glad we could visit about the board. Every physician should be aware of the board and how it operates. We need to know where to get information on the requirements and, yes, the prohibitions about medical practice. And also what to do in the event a complaint is lodged against one of our friends. So I hope this has been helpful to you.
Oh, it's been really
Totally.
helpful.
Yes, thank you so much for your time.
Good deal. Oh, and keep me posted on your licensure application.
Oh, definitely. Yeah.